Good morning and a warm welcome to one and all listening to this video. I, Enaniya, Assistant Professor, Government Law College, Ajmer, is going to teach you the emergency provisions as contained in our Constitution. So, we were studying part 18, in which we must understand the various provisions relating to the emergency and the various aspects relating to the same. So far we had completed Article 352, okay, and now we shall continue with Article 353. So, what are the consequences? Let us understand. Article 353 reads, while a proclamation of emergency is in operation, then, Clause A, notwithstanding anything in this Constitution. So there is a use of the word notwithstanding. So non obstante clause is used. So it will have an overriding effect against all the provisions. Okay? So while a proclamation of emergency is in operation, then, notwithstanding anything in this Constitution, the executive power of the Union shall extend to the giving of directions to any state as to the matter in which the executive power thereof is to be exercised. So let us interpret it accordingly. So, what it does, what its net effect is, that it is dealing with the federalism, which is a basic feature of Indian Constitution. So in normal times, so in the times of peace, what happens is we are a federal constitution. Now what happens by virtue of Article 353 Clause A is that now the Union executive is having the power to give the directions to the state in the manners in which such executive powers of the state has to be exercised. So we must understand that the Constitution, which was federal at the time of peace, becomes unitary at the times of emergency. So we must understand why this provision has at all been created. What is the importance? What is the need for having such a provision? So we must understand the basic concept that if a nation is at stake, if the nation is posed with a great or immense threat, then what needs to be done is to protect that nation first. Okay? So if you are able to protect that nation, then and only then you can have the provisions in effect. Okay, so therefore what you need to do is you need to save the ground. So therefore the Constitution, which was federal at the times of peace, becomes unitary in the times of emergency. Clear? So therefore the Union has the power to direct the state executive to exercise its executive power in accordance with the directions issued by the Union Executive. Clear? So let us proceed with Clause B. The power of the Parliament to make laws with respect to any matter shall include power to make laws conferring powers and imposing duties, or authorizing the conferring of powers and imposition of duties upon the Union or officers and authorities of the Union as respects that matter, notwithstanding that it is one which is not enumerated in the union list. So it again is touching the federal fabric of Indian Constitution, and the net effect is by virtue of the clause B as contained in Article 353. Now the Parliament has all the power to make laws, and such laws can delegate power and impose duties upon the union or its officers. Okay? Despite the fact that such a matter is not enumerated in the union list. So, by the plain reading of the term emergency, we must understand that such an emergency calls for the use of extraordinary powers. So, therefore, in such a situation, what has to be done, and therefore, we, in order to protect our country, in order to safeguard the interests of the people of this country, have to work accordingly, and therefore we shall become unitary at the times of national emergency. Clear? So therefore, now let us conclude this Article 353, Clause A and Clause B, which say that the union executive has the power to give the directions to the state executives, and the state executive have to work accordingly. Clear? And the second thing is the parliament will have the power to make a law with respect to matters even which are not enumerated in the union list, and by virtue of that particular law, it can, by the creation of that law, confer the powers upon the union and impose duties as well upon the union as well as the officers of the union. Now, let us understand the proviso attached to Article 353. Provided that where a proclamation of emergency is in operation only in any part of territory of India. As we all know that in the earlier provision we had read that the national emergency can not only be imposed throughout the territory of India, but it can be restricted, if at all the need is so, to a particular part of the territory of India. So therefore, we must understand this proviso in light of that particular provision. So provided that where a proclamation of emergency is in operation only in any part of the territory of India, the executive power of the union to give the directions under clause A and the power of the parliament to make laws under clause B shall also extend to any state other than a state in which or in any part of which the proclamation of emergency is in operation, if and insofar as the security of India or any part of the territory thereof is threatened by the activities in or in relation to the part of the territory of India in which the proclamation of emergency is in operation. So let us conclude this proviso. So listen very carefully. Now we know that the proclamation of emergency can be made with regard to the whole of the territory of India or a part of Indian territory. So if in case it is imposed only in a part of the territory of India, then too the union executive shall have the power, and also the parliament shall have the power to make law as mentioned in the above clause B. Okay, so we are talking about the union executive's power and parliament's power as mentioned under the clause A and clause B of article 353. So both the union executive as well as the parliament has the power to make such laws and to issue such directions to other states as well, in which the proclamation of emergency is not in operation. But the condition precedent is that the security of India or any part of the territory of India is threatened by the activities in relation to the part of the territory of India in which the proclamation of emergency is in operation. So let us do the math. What happens is, if a particular part is disturbed and emergency is in operation in that particular part, and if by activities in that part the security of India or the security of other parts of the territory of India are also threatened, then such directions can be issued by the union or such laws can be made by the parliament with regard to the other state, with regard to the other parts as well, so as to counter, so as to combat with that particular situation. Okay, so what is our priority is to counter, to neutralize that particular situation. Clear? All right. Article 354. Let us move on to that particular part of Indian Constitution and let us understand what this particular provision means. Article 354, clause 1. The President may, while a proclamation of emergency is in operation, by order, direct that all or any of the provisions of Articles 268 to 279 shall, for such period not exceeding in any case beyond the expiration of the financial year in which such proclamation ceases to operate, as may be specified in the order, have effect subject to such exceptions or modifications as he thinks fit. So, the net effect of this clause 1 as mentioned under Article 354 is that the President shall have the discretion that he can cease the operation of Articles 268 to 279. Articles 268 to 279 deals with the distribution of revenues between the union and the states. Okay, so it is a revenue distribution matter. Okay, so what he can do is, while the proclamation of emergency is in operation, he has the discretion to direct that all or any of the provisions of Article 268 or 279 shall, for such a period which shall not exceed in any case beyond the expiration of the financial year in which the proclamation ceases to have effect. Okay, so he can cease the operations operation of the articles 268 to 279 or any of the articles between 268 to 279 or all of the articles from article 268 to 279 can be seized to have effect by virtue of president's order, and if he wishes he can issue directions that the order shall be subject to such exceptions or modifications which are issued in the order itself. Okay, so he has the discretionary power to seize the effect of articles 268 to 279 or any of the articles in between. Okay, so it can be done by him and it shall continue for the maximum period of the expiry of the financial year in which the proclamation of emergency ceases to operate. The logic, the concept, the requirement behind the creation of this particular provision is that since emergency requires for the exercise of extraordinary powers, the movement of forces might also be required and various other things might be done. So for that the money is required. Okay, so therefore the distribution of revenue at that particular time can be stopped or paused because the money has to be directed towards countering that particular situation. So therefore the center or the union must have the money, the financial power as well to counter or to combat that particular situation. So therefore it can seize the effect of the revenue distribution provisions. Okay, so our lecture for today ends here. We shall continue in the next video. So I thank you all for listening so carefully. Have a great day ahead.